This is Alex Berger, impaired driving defense attorney out of the Upper Peninsula, and today I'm going to talk about the breathalyzer. This is the preliminary breath test, the PBT, that they use on the side of the road to try to figure out how much you've had to drink. Now, technically, this device is called a preliminary chemical breath analysis device, but I'm going to call it a PBT for the purposes of this video. I'm just going to go over some of the interesting aspects of it and some takeaways that you might use if you ever find yourself in a situation where you might have to take one of these. In the entirety of the state of Michigan, they use a device called the LifeLock FC10. It is a black and yellow device, relatively simply to use, and I will post a link to the operator's manual in the description of this video that's put on by the state police. It's really helpful if you're ever interested in it. Unfortunately, it's really hard to buy one of these devices yourself and take a look at it. They're almost strictly for law enforcement. So these are preliminary breath tests, PBT, and they're used by law enforcement to try to figure out if they're going to arrest someone if they suspect that they are impaired by alcohol or drugs. Now, one interesting thing about the PBT is that it's baked into the manual for impaired driving investigations put on by the National Highway Traffic Safety Administration, the standardized field sobriety tests. They have 3 standardized field sobriety tests, and then it indicates that you're supposed to do a PBT after you do the field sobriety tests. So in every impaired driving investigation, if they're following their training, law enforcement should do a PBT, even if they don't suspect alcohol and they only suspect drugs. So if the police are doing their investigation correctly and following the National Highway Traffic Safety Administration's protocol, then they should do one of these in every single impaired driving investigation. Now, they don't always, but it's interesting that they're supposed to. So that's the first thing, is that they're supposed to be done in every single impaired driving investigation. The second interesting thing is that it is not a crime and it does not affect your driver's license if you refuse to do the PBT. So if you are pulled over and they want to do the field sobriety test and they want to do the PBT, they're going to read you a short statement about how it is civil infraction if you refuse the PBT. What that means is that if you say no thank you to the PBT, you'll get about a $150 fine. It will not affect your driver's license. It will not lead to any criminal charge or enhancement of any criminal charge. So usually what I tell people, if you've had anything to drink in that day, last 12 hours, and you can tolerate a $150 fine, you should refuse that PBT. The only consequence is that $150 fine, and it's really not beneficial, I think, in a situation where you might show anything to blow into that. Which leads me into the third interesting thing about the PBT, is that it's not evidentiary. What that means is that generally the results of the PBT cannot be used in court against you. And the reason for that is mainly because it's not a terribly accurate device quantitatively, meaning it doesn't necessarily show an accurate reading of what your blood alcohol content is through your breath. In order to get evidence that they can use in court about what your blood alcohol content is or what your drug blood content is, they have to either send it out to the state crime lab to do a blood test and a blood analysis on some very sophisticated and calibrated devices, or they can, for the breath alcohol, there is a device back at many police stations called an intoxicated 9000, which is an evidentiary breath test, meaning it's a well-calibrated, more sophisticated device that tests your breath to see what your blood alcohol is. Now, I have a lot of opinions about all these different testing mechanisms, but the takeaway here is that the PBT is not accurate enough generally to be used as evidence against you. It is just for law enforcement to try to make that arrest decision. It is one of many factors that they're supposed to use, but if someone blows above a 0.08, the legal limit, the chances of them getting validly arrested are pretty high. There are 3 instances where the PBT can be used in court against you. And this is from MCL 257625A2B. And the 3 instances are interesting. The first one is if you're challenging the validity of the arrest. If you say that you were unconstitutionally arrested and the case should be dismissed, either side can bring in the PBT to show that the arrest was either valid or invalid. So if the PBT came back at a 0.06, that's well below the legal limit, and that person was arrested, the defense might use that to show that the arrest was invalid. And if the PBT was at a 0.2, well above the legal limit, and the officer arrested an individual, the prosecution could use that PBT to show that there was probable cause for that arrest. The other two exceptions where this can be used in court are, one, if the defense calls a witness that says that the blood alcohol content was higher than the PBT, the defense can use that PBT result to basically call out their own witness that got it wrong or didn't say what they wanted them to say. And then the third exception where you can use the PBT in court is if a prosecution witness says that the blood alcohol content was lower than the PBT result, the prosecution can use that PBT result to basically say that their own witness was mistaken or incorrect. I've never seen these two exceptions work or actually happen in court. I think they're incredibly rare. It'd be interesting to hear if anyone has heard of it being used. But generally, these PBTs are only talked about in court if we're challenging the validity of the arrest. In terms of the actual procedure, the PBT is part of the standardized field sobriety test protocol developed by the National Highway Traffic Safety Administration. So you do the standardized field sobriety test, then you do the PBT. In every case, you're supposed to do it. Even cases where there's not alcohol suspected and it's only drugs. The National Highway Traffic Safety Administration protocol says that you're supposed to do the PBT every single time. Now, we don't always see this, but I do think it's important, and I've used it to some success in cases, to call out law enforcement when they don't do the PBT, because it is supposed to be done pursuant to their training and pursuant to the training that all law enforcement gets. So every impaired driving investigation should have a PBT, but they don't always. The other interesting thing about the protocol for it is there is supposed to be a 15-minute waiting period before the PBT is given, and that's to observe the individual to make sure they're not throwing up in their mouth, burping wetly, or putting things in their mouth like pennies or other stuff that's supposed to affect it. Oftentimes that 15-minute waiting period is kind of cut short because officers expect that the investigation itself will take about 15 minutes, but sometimes they only take 10 minutes. So a lot of times the officers will pull out the individual, they'll run them through the field sobriety test, and they'll ask them to do the PBT, and they've only been observing them for 10 minutes. Technically, that PBT result can be excluded from the entire investigation. Meaning if that's what they base their arrest decision on, we can get that excluded and potentially get the case dismissed. So that 15-minute waiting period is critical. Generally, the takeaways from this are you should refuse the PBT if you've had anything to drink, if you can tolerate a $150 fine. The PBT results, if you do it, aren't really used as evidence against you in the case. They're only used for the arrest decision. And, you know, that 15-minute waiting period really isn't going to affect someone that's dealing with it, but it is something that your attorney should definitely look at if you do get arrested and charged with operating while intoxicated. I hope this was helpful, and post any questions in the comments.